Hello peeps, I'm just going to read through this document which was from the District Probate Registry at the Crown Court. So it says the origins of probate jurisdiction. The functions of a probate court are to decide whether or not a document is entitled to probate as a testamentary paper, a will, and who is entitled to become personal representative in brackets an executor named in a valid will, or if none, as administrator to administer the estate. So from a very early period in English law, and possibly a result of the influence of Roman law, personal property, goods and chattels could be left to others on death by a will. Originally, a will could be anything from an unwritten deathbed statement to a formal written, sealed and witnessed document. It could appoint an executor to administer the property left by the will. So that's talking about what the office of executor is. It's an appointment. The Church encouraged the making of wills, and the ecclesiastical courts assumed control over determining the validity of wills dealing with personal property and making grants of authority to executors of such wills to act. The person responsible for doing so was usually the bishop of the diocese where the testator dwelt. He became the ordinary, and his court, where the will was proved, was the court of ordinary. However, where the deceased had effects in a diocese other than where he died, and of such an amount as to be considered notable goods, the will had to be proved in what was called a prerogative court of Canterbury or York. Prior to 1858, their decisions were of similar authority to the later probate court. There were also some courts barren which exercised probate jurisdiction. Land was not dealt with by wills and had its own rules about who could inherit it, called rules of inheritance. Disputes concerning the rules of inheritance were decided by the King's Court. Probably because attached to ownership of land were duties to the owner's immediate lord and ultimately to the king. However, not everyone made a will, and the practical problem was what to do with the belongings of someone who had died without making a will, called an intestate. The law on this subject was for a long time uncertain, probably dependent on local custom and probably ill-enforced, and it took a long time for rules of succession to develop. Statutes made in the reign of King Canute and William the Conqueror stated how the property of an intestate should be dealt with between members of the intestate's family, but did not say who was responsible for seeing that it went to the people it was supposed to go to, that is, who was responsible for administering the estate. By the reigns of Henry I and King John laws and statutes, including the Magna Carta, recognised that the goods of the intestate could, as well as being used to pay his debts and being shared among his family, be used for pious uses, that is, for the purposes for the good of the soul of the deceased, which could of course include church purposes. The ordinary's jurisdiction over wills and executors made the possibility of application of the intestate's goods for church purposes could each have been excuses for a bishop to seize and dispose of an intestate's goods within his sphere of power, his diocese. By 1285, the Statute of Westminster II, Chapter 19, recognised that possession of the personal property of an intestate passed to the ordinary, who had to pay the deceased's debts out of the property, and who was then entitled to dispose of the remainder for pious purposes, as he thought fit. The ordinary appointed an administrator who at this stage was nothing more than the ordinary's bailiff or deputy. The ordinary could deal with an intestate's property only if he could actually get physical control over it, and the administrator could not bring any legal proceedings in relation to the estate of the intestate. The intestate's family could not force the ordinary or the administrator to distribute to them any of the intestate's property. In 1341, Archbishop Stratford published a constitution stating bishops, in case of persons dying intestate, after payment of debts, shall distribute and employ remaining goods to pious uses, to the relations and servants and friends of the deceased, or others for the benefit of his soul, retaining nothing for themselves, unless perhaps a reasonable compensation for the labour of the ordinary.